Your case is called for jury selection. Your lawyer is stuck in traffic. Can the judge dismiss your case because your lawyer is not ready to proceed forward? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, he could. Now you might be saying to yourself, how could that possibly be? It has now taken you almost 2 or 3 years to finally get to the point where your case is ready for trial. Your attorney is actually ready for trial. You have been prepared for trial. Your attorney has prepped you for trial. All of your experts are ready to go. All of your evidence has been subpoenaed into court. All of your medical records are in court waiting to go. And now, at the time of the calendar call, it's 9:30 a.m. The judge calls all the cases on his list. And now there are lots of attorneys that are going out for jury selection. Your attorney doesn't answer the calendar call. So now there's a big courtroom, lots of attorneys waiting to be called up for jury selection. And guess what? When they call your case, the defense lawyer stands up and says, "Defense ready." And the judge says, "Where's the plaintiff's attorney?" He's like, "I don't know, Judge." Now the judge has a choice. He can mark it second call, which means after about 15 minutes or half an hour, the judge will then call whatever cases are remaining on his calendar again to see if any stragglers come in late, and then call it for the second time. It's called second call. That's a possibility. On the other hand, the judge may want to dispose of all cases that are actually not ready to go. In that instance, your attorney has a problem. Your case now has a problem. If, in fact, the defense attorney stands up and says, "Judge, defense is ready," and the judge says, "Where's the plaintiff's attorney?" The defense lawyer says, "I don't know, Judge." The judge he has the authority to go ahead and dismiss that case. Now, it's not being dismissed on the merits. It's being dismissed on a technicality. And what's that technicality? That your attorney is not ready and prepared and ready to go forward. And because of that, the trial assignment judge has the absolute authority to go ahead and throw that case out. Now, what happens then? What happens then is that your lawyer finally shows up in court. He speaks with the court clerk to find out what happened to the case because he's now late. He was stuck in traffic. But the clerk tells him, "I'm sorry, your case was dismissed." Now your attorney has a problem. So what does he do? Well, there are a couple of things you could do. You could go with your adversary. The two attorneys could now try and see the judge and speak to the judge in private to see and explain. Say, "Judge, listen, I was stuck in traffic. Is there any way you could restore this matter to the calendar?" And that would simply be an administrative matter by the clerk to go ahead and check off the right box to say, "Yes, okay, everybody's here. Now go pick a jury." That's an administrative matter. And that's a possibility, and that could happen here in New York. However, the judge could turn around and say, "Counselor, you weren't here. You didn't call the court. You didn't call my clerk. You didn't call your opponent to let him know you're stuck in traffic. And because of that, your matter is now dismissed. You want to get this back on the trial calendar? Make a motion." Now, what's a motion? A motion is a formal written request to the court to take some type of action. And in this instance, it would have to be to put the case back on the trial calendar. The attorney has to give a good valid reason, a good explanation about why he wasn't present at the calendar call and show that there's no real prejudice here. That's really important to be able to show. If the defense lawyer can show that there is extreme prejudice to allow the matter to go back on the trial calendar, now your attorney has a bigger problem. But in all likelihood, the trial assignment judge will likely allow the case to be put back on the calendar. So what does that really mean for you and your case? It means that your case is going to go on the bottom of the stack of cases waiting to be called up for trial. You were sitting around waiting for 8 months, 10 months, 12 months for your case to go from here all the way to the top of the pile to be called for jury selection. And now, guess what? If the judge allows you to go ahead and put your case back on the trial calendar, in all likelihood, he's going to have your case go to the bottom of the pile, and now you must sit and wait all those months to get your case back all the way up to the top of the pile until finally your case is called for trial again. That's what can happen if your attorney is not present at the time your case is called to go pick a jury. The judge has the authority to go ahead and dismiss your case. So why do I share this with you? I share this with you because this can happen and does happen from time to time. And you know what? Nobody really talks about this. This is more like inside baseball where the attorneys are familiar with what goes on, but not many people, not many consumers, not many litigants are familiar with the process and the procedure about what actually happens when your case is ready for trial. You know, I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you have questions about your matter, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.